I'm Dr. Stephanie Walls, Associate Professor of Political Science, and on behalf of the faculty and staff, I'd like to welcome you to BGSU Firelands and this evening's Know the Ohio Ballot Issues Forum. Modern democracy rests on the concept of representation. And so our responsibility as citizens usually centers around developing a base of knowledge about the candidates so that we can pick the person who best reflects our values. However, there are opportunities at the state and local level for us as citizens to do so much more. When issues are placed on the ballot, whether it's by the state legislature or through citizen petition, the people are promoted to policymakers. We get to actually answer the questions that are placed on the table. But with this opportunity, of course, comes a great burden and a great responsibility, because then we need to be informed about those issues. That is certainly where an evening like this comes into play as an invaluable tool for us. Out of a commitment to open discussion and knowledge, we have come together tonight to educate, to learn, and to ultimately form a position that will inform our vote on both issues 1 and 2. Thanks to the League of Women Voters for co-sponsoring this event and providing both a moderator and timer for us. Thanks to Tom Whaley of TW Teleproductions of Sandusky for making a video of tonight's event so that the benefit of our discussion tonight will reach far beyond these walls. Many thanks to Amy Gruby for developing this idea and working to get it off the ground so that we could all be here tonight. Please note that there is a voter registration table in the back of the room. If you're not registered to vote, please stop by and complete a form. Also, any Firelands students who are here and need an attendance verification form for credit can pick one up from Michelle Meredith in the back of the room. Wants to turn around and see her there? Also, you have the opportunity to ask questions tonight. So we'll have index cards going around so you can write your question down, and those questions will be forwarded to our guests tonight. Our moderator tonight is Lee McLaird of the League of Women Voters of Bowling Green, where she has been a member since 2004. She has served on the board as secretary and 2 terms as president. Her committee activities have included education and voter services, helping put together candidate forums and other voter information programs. This year, she was elected to serve on the board of League of Women Voters of Ohio. She's proud to be a 3rd-generation member of the League of Women Voters. Ms. McLaird worked 25 years in the Center for Archival Collections at Bowling Green State University as reference archivist and rare books curator. There, she assisted researchers in using local government records from throughout Northwest Ohio and historical manuscript collections, including those of state legislators such as Charles Kerfess and U.S. Congressional Representatives Delbert Latta and Thomas Ashley. Ms. McLaird, the floor is yours.
Thank you. It's a very lovely facility. I'm very happy to be here, and I'm very pleased to know that people are going to be discussing these issues in depth, both at this event and as we take off home. We have time before the elections to think carefully about these issues, and I know that you will all take an interest in doing that. I am to describe the rules for the evening. First thing that you need to know is that the League of Women Voters is a nonpartisan political organization. By this we mean that we do not endorse candidates and we do not endorse parties. We can endorse issues if we have an already established written position on a particular issue. These stands are determined by a long period of study and working together to form a consensus on the issue, and then the issue or the statement is approved. Only on that basis can we go out and advocate for a particular issue. In this case, in case of both of these issues tonight, the League of Women Voters of Ohio voted specifically not to take a position on either issue, but we do, as always, write up the pros and cons of both sides of the questions so that you can get a better idea of where everybody's coming from. If you are interested in more details on that, there are printed copies of our analysis of both of these issues tonight on the back table by the door where you entered. If you have not picked up a copy, please feel free to help yourself, because that's what we do these for. Our rules for the evening mean that first we will discuss issue number 1, which I will read the summary of in a moment, which is the Marcy's Law issue, and issue 2, which is on the drug price question. Okay, and our pro speakers will speak for 5 minutes. Con speaker will immediately follow for 5 minutes. There will be 3 minutes of pro rebuttal, followed by 3 minutes of con rebuttal. And then we'll have 15 minutes or so for audience questions, which again are to be submitted in writing, and we'll go through them at that time. After that period is concluded, we will introduce issue 2, as well as the speakers, and once again we will follow the pattern: 5 minutes for pro presentation, 5 minutes for the con presentation, 3 minutes for the pro rebuttal, and 3 minutes for the con rebuttal. And once again, we will have time at the end. 15 minutes is suggested, but we'll see how the questions go at that time. And then we will close for the evening. So that is the plan for this evening. First of all, question 1, and I will get there in a moment. And I will read those of you, there it is. Issue 1 is called Marcy's Law, or Crime Victims' Bill of Rights. A brief summary is as follows. Issue 1, Marcy's Law, will alter the state constitution to significantly expand the rights of victims in Ohio. The law would ensure that crime victims have a meaningful role throughout criminal and juvenile justice systems. It would provide crime victims with specific constitutional rights, including the right to be treated with fairness and respect for the victim's safety, dignity, and privacy, to be notified about and present at proceedings, to be heard at proceedings involving release, plea, sentencing, disposition, or parole of the accused, to a prompt conclusion of the case, to reasonable protection from the accused, to be notified about the release or escape of the accused, to refuse an interview or deposition at the request of the accused, and to receive restitution from the individual who committed the criminal offense. There is already language addressing rights of crime victims in the Ohio Constitution, which voters passed in 1994. However, Marcy's Law would replace it with language that, as described above, would expand the existing rights of victims and would establish new rights for victims. So speaking for issue 1 on the pro side, Kevin Baxter was first elected prosecuting attorney in 1988 and is the longest serving prosecuting attorney for Erie County. He is the past president of the Ohio Prosecuting Attorneys Association, the past vice president of National District Attorneys Association, and served as special prosecuting attorney in 9 counties. He's the founder and president of Michael's House, Erie County's Child Advocacy Center. He is the chairperson of Erie County Community Correction Board. Also speaking on Yes, Issue 1 is Paul Sigsworth. He states, I am honored to have served the citizens of Erie County as a member of the Sheriff's Office during my entire professional law enforcement career, beginning in 1983. I have worked in all areas of the agency as a dispatcher, jail deputy, patrol deputy, detective sergeant, operations captain, and since 2012 as your sheriff. I graduated from the 216th session of the FBI National Academy in 2004. My wife of almost 29 years, Kathleen, and I live in Milan Township with our 2 children. Speaking for the no side of issue 1 is Jeffrey L. Oglesby. A practicing attorney in Sandusky, Jeffrey was born and raised in Sandusky. He graduated from Sandusky High School in 1973 and enrolled in The Ohio State University, where he graduated in 1977 with a Bachelor of Arts degree. Between 1977 and 79, Jeffrey attended Bowling Green State University. In 1979, he enrolled at Cleveland State University's Marshall College of Law, where he graduated in 1981 and passed the Ohio bar exam in May of 1982. He then joined his father, R.B. Oglesby, and started the first black law firm in Erie County. Jeffrey is presently the president of Oglesby and Oglesby, LPA, with a staff of 7. He has successfully argued criminal and civil cases before the Ohio Supreme Court, with numerous precedent-setting cases in the Court of Appeals. Certified by the Ohio Supreme Court to represent indigents in capital murder trials, he has handled numerous death penalty cases in the state of Ohio, as well as written appellate briefs for those convicted of the death penalty. In 2013, Jeffrey argued successfully the landmark case of Disciplinary Counsel versus Harris before the Ohio Supreme Court. Jeffrey was an instructor at Ohio Business College, has done research for numerous boards, and has instructed at legal seminars along with other local attorneys addressing juvenile rights. Jeffrey has 7 children, 3 deceased, 6 grandchildren, and has been a lifelong member of the prestigious and historic Second Baptist Church located in Sandusky. So, beginning, as I described earlier, first speakers on the pro side, Baxter and Sigsworth, will have 5 minutes to present their case. They will be immediately followed by Jeffrey Oglesby on the con side, again for 5 minutes. Then there will be 3 minutes of pro rebuttal, 3 minutes of con rebuttal, and then we will have time for audience questions. So if you come up with a question that you're curious about, let someone know so that you can have a card to write it down and turn it in so that we can ask the questions. So I will turn the microphones over to the pro side, Baxter and Sigsworth. Thank you.
Well, first of all, good evening, everyone. I'd like to thank Firelands College, Bowling Green State University, and Stephanie for making this fine facility available to us tonight. I'd also like to thank the League of Women Voters for sponsoring this program this evening, and I'd like to thank Amy, I think, for contacting me to be here tonight. I speak to you tonight as a career law enforcement officer. I can tell you that I'm in favor of issue 1 because of the things that I've seen during my career. Mr. Baxter will speak to the specifics and the technical legal issues that apply to issue 1, as will, I'm sure, Mr. Oglesby. I have to stop for a second. If you have never seen Mr. Baxter or Mr. Oglesby in court, it is truly a thing to see. With all due respect to the members of the bar that are here tonight, these 2 gentlemen are probably 2 of the most skilled attorneys in front of a jury that I've ever seen. So I'm not sure if they'll express themselves in that fashion this evening, but it is something to see when they do their work in court. Anyway, issue 1. Issue 1 is important to me because I have seen the effects of criminal behavior on victims at calls that I've responded to over and over again. And I'm talking victims of violent crime who are going about their business, living their lives, when they were targeted by a predatory felon who inflicted severe injury, both physical or emotional, on those persons, or they were murdered, and their family is left behind to struggle every day with what was done to these folks. There is, as was indicated, a current section of the Ohio Constitution that addresses these issues. There is a current statute in the Ohio Revised Code that addresses these issues, but I think it is vitally important that the victims of these criminal acts have a distinct voice and a distinct opportunity to express themselves in court, express themselves directly to the court in a way that is not currently available to them in the Constitution or in the Revised Code. That's why it's important to me, and if you've ever had to look in the face of some of these victims or some of their family members, you would understand exactly what I'm saying to you. So for that reason, I support issue 1. I'm going to sit back and let these gentlemen discuss it further. And so I'll yield the rest of my time, Diane, to Mr. Baxter.
Thank you, Sheriff. Thank you for those kind words, and thanks for the invitation to appear tonight and to make the case for Marcy's Law, which is issue 1. on the ballot this November. In my office, I've been there about 30 years now, and I've seen a tremendous change in the law in all different facets, including victims' rights. We handle about 2,500 victims a year, because we handle all the municipal courts. So we work with the victims through the entire process. And because of longevity, I've seen a time when victims had really no rights. They had no voice. Many times they were not only victimized by violent crime, but victimized secondly by the criminal justice system. Well, that was changed to a large extent in 1994 when they passed the constitutional amendment to give victims' rights more of a voice. And that went a long way, but it didn't go all the way. What this really is an equal rights amendment. What it allows to happen is that to put victims on more of an equal footing with constitutional rights. Constitutional rights to not only be present in a courtroom and throughout the proceedings where they were allegedly tremendously affected. As I tell people in my office when I talk to them like on a yearly basis, I'll thank them for the work that they've done, but I'll say, you do very important work. You make a difference in people's lives. And that's because we are seeing people when they're going through probably the worst time in their lives, tragedies. Survivors of murdered children or family members or rape victims. People's homes have been burglarized. They feel very violated in that aspect. So we deal with those type of things. Currently, to give you a little more specifics, currently, and we have some limited time, but currently you have a right, if you're a crime victim, to be notified. You have a right to understand what your rights are and be explained the process. You have a right to be present throughout all the proceedings. You have a right to have a voice at the sentencing. But this law changes that aspect. They also give you a right not only to be present at all the proceedings, but also to have a voice when those proceedings may affect your rights as a victim. For example, bail or bond, those type of things. So you have a voice there. Also, right now, as the law is present, you have a right to sit through the criminal trial. But many times, the judge has the right to kick you out of the courtroom if he thinks, or she thinks that you will adversely impact the rights of the criminal defendant because of separation of witnesses. This does away with that. You have a right to sit there, as the defendant does, in that courtroom and watch the trial. The trial that's adjudicating this person as to whether or not your rights or you were violated as a criminal victim. So what it does really today is to put, I think, a more equal footing. It doesn't do anything, does nothing to take away the rights of the defendant. They still have all their constitutional rights and protections there. It simply puts victims of crime on equal footing to be not only present, but be heard through proceedings. Also, it also requires us to expeditiously handle the cases. The defendants have the right to speedy trial. The victims now also have a right to speedy trial, rather than this case being dragged out for months and sometimes years. So for those reasons, I would support and ask you to support issue 1.
Good evening. As was stated earlier, my name is Jeffrey Oglesby, and I'd like to thank Dr. Walls, the League of Women Voters, Ms. McClure, Ms. Gruby, and of course Bridget Green Churchwell, who wrote me into doing this. I will say this, ladies and gentlemen, that until I was called, I actually had no idea that issue 1 was even on the ballot, like a lot of people. But through the weekend, I found out quite a bit about issue 1 and what's happening. I think the audience kind of needs to get a feel for why we even have laws. When I taught at Ohio Business College, I think I may have discovered the answer. We have laws because people create mischief. That's why we have laws. And so why do we have this particular law? You know, it's not the criminal defendants that are doing this. It's not the criminal bar that's doing it. These laws are for the victims in the court. It's telling the prosecutor what you have to do. It's telling the judge what you have to do, not the criminal defendant. So when I speak con, you know, I'm a little bit perplexed because this law it came about not through initiatives by the people in Ohio. In researching this law, I made a joke this weekend at the NAACP forum that if I sent in $1 in opposition to Marcy's law, I would be the top contributor against the law. There's like $3 million put up for it and $0 against it. What happened is a man out of California who was a millionaire decided that he was going to fund this law because of what happened to his sister. So what he did is he hired a public relations firm, another woman with the Victims of Crime Advocates. He plunked down $2 or $3 million, paid people to get the signatures, and then they put it on the ballot. So in reality, the citizens of Ohio are not really the policymakers here. The millionaire from California is. Now, does that mean it's a bad law? Perhaps not. But when you look at it, the problem with the law is not so much having a victim's rights law, it just doesn't have any teeth to it. In this particular law, if the person's rights are violated, there's virtually nothing that the victim can do. They can't sue, they can't file a grievance, there's nothing that they can do. If this law said that if you don't do something for a victim, the victim can sue, then perhaps it would be a good law. But as it is now, it's just basically, window dressing to make people feel good. The things that we're talking about, whether a victim can be in court, victim can't be in court. It's up to the prosecutor. The prosecutor can sit anyone they want at the table. But they usually choose to have a police officer sit there. The victim can come in there. I have never, for once, ever asked the victim to not be in the courtroom. Additionally, as a defense attorney, a victim's pain is my pain. Kevin and I had a case early on in our career, and I think it was the forerunner for Michael's house. And I represented the mother of Michael. And Michael was killed by her boyfriend. And I still see that child. I still see that child on that slab. And if you don't think that that will not move the defense attorney, then we just can't be moved. We are concerned about the victims. I usually talk to the victims. I usually, in speaking with them to understand their concerns. And when I do that, I usually get a feel for them and they get a feel for me. That I say, look, listen, I'm protecting my client's constitutional rights. I don't have necessarily a stake in the game. And any questions they want to ask me, they can. When I have death penalty cases, every now and then I'll write the victims and just let them know, listen, we have a constitution. You can ask me any questions you want. It doesn't have to be adversarial. I think this is a bad law because it just does not give the victims enough. They should put some teeth in it. They should actually rewrite it. And if the citizens, the problem with this law is that the victims didn't get together and write it. Mr. Robbins, I think his name is, put the law together because of what happened to his sister. So if a coalition of victims and people that really cared about victims got together and wrote a law, this is not the law that they would write. They would make it much tougher and much stronger and would actually give the victims some rights in courts, which they do not have.
Rebuttal.
Actually, the law does give them some rights, and that is the right to appeal. The law provides the victims with rights to appeal if any of these rights are denied by the court or anybody in the criminal justice system. So there is a remedy to the appellate court on that. Again, this law is one in which it provides, I believe, equal footing, much needed, with regard to victims of crime with their counterparts, the criminal defendant in a particular case. My experience has been that whenever a separation of witnesses is asked for, it usually involves the victim. The victim usually is a witness in the case. So the victim has to leave the courtroom and not see the trial. That happens every day in this state. This will prevent that from happening. The victim will have the right, just as the criminal defendant has the right, to sit through the trial. That's got to make fundamental sense, fundamental fairness. The bottom line is that the criminal justice system, believe it or not, folks, is not primarily dedicated to finding the truth. It's not. The criminal justice system is meant to protect the rights of the criminal defendant. That's why when police forget to read the defendant's rights, he gets thrown out, the confession. Not because it's not true, but because they are suppressing the truth in order to protect the defendant's rights. That's why when the police don't do a proper search and seizure, the evidence is thrown out. Not because it's incriminating or the truth, it's because they're protecting the criminal rights. So there's a vast imbalance here. And what this law proposes to do is to try to cure some of that imbalance by providing the victims equal constitutional rights to the criminal defendant. It just makes sense.
You know, just in rebuttal to that, you know, no defense attorney has a real argument with the victim being in court. I mean, you know, they certainly have that right to be there. And any prosecutor, and I say this firmly, can have the victim sit at the table with them. They have the right to have anyone sit there that they want. But generally speaking, the person that looks the best is the police officer with the uniform. That's just common sense. Now, Mr. Baxter talked about the concept of the right to appeal. When you compare the full text of the Bill of Rights, it says, yes, you have the right to appeal. When you compare that to the federal law, there's a correlating federal law that puts a limit on how long the appeal should last. The Court of Appeals has to make a decision within 3 days. This is in federal court. And in the federal court, the decision everything has to be done in 5 days. This text does not do that. It just leaves it open. It also talks about restitution, okay? And where does that restitution come from? Does it come from the court costs? Is it paid first? This Bill of Rights that was written extremely poorly. And it wasn't done based on what victims wanted. It was based on what Marcy's brother wanted. And I would submit to you, ladies and gentlemen, that this should be voted against. And then let true victims come in and say what they want. Not what this millionaire wanted that bankrolled this, set it out, paid people to go to get the petitions based on this company that did it. I would submit to you, ladies and gentlemen, that not one citizen went out and got signatures. I know who signed for the full text proposed amendment. It was the two of them were the people that had the companies that did the surveys. And another one was a lady that was the head of a victim rights company that would profit from this. There's $9 billion worth of victim rights funds. And this is a precursor to have those type of businesses set up, and it's a charade. If you really look at this, any victim will tell you they want more. They want way more than this. And when I look at it, I can think of 1,000,001 things that should be in there that should give it some teeth. That you cannot do anything to the judge, the prosecutor, or law enforcement if your rights are violated. Now you can go take it up to the Court of Appeals, but who knows how long that's going to last. The federal law has more teeth in it than this because it was written by victims. This wasn't.
Let's thank our speakers. Just a minute. Mark me for 15 minutes. Always technical difficulties when we're working there. We'll try that. I have 1, 2, 3 questions here, possibly 4. Are there other questions? Yes. And have someone gather them up. Hold your questions up. And I'll begin with the first question that I have here. Each person will get about a minute, I think, to respond if you want that much. This question says, is issue 1 not vengeance rather than justice? And why does not the legislature address this question rather than add to the already cumbersome state constitution?
I can take that. As was stated earlier, this was an initiative. In Ohio, the quote-unquote citizens have the right to petition their government. But that does not preclude outsiders from coming in here petitioning our government with bags of money. The state legislature, the Ohio Prosecuting Attorneys Association, the victim rights advocates could have easily put together some form of legislation that would assist victims who are truly in need. The man's name was Henry T. Nichols III. He's a millionaire. He owns broadband or something like that, and he's been going across the country financing these type of deals in states like ours that allow for initiatives to happen. This wasn't citizen-driven. This wasn't even cause-driven. It was Henry Robbins-driven because he was a multimillionaire. $3 million for it, $0 against it because he just snuck in. Now, as an attorney, I'm not saying victims shouldn't have rights. I just think they should have better rights than this.
There's a very good reason why it's not legislatively handled. The Constitution trumps the legislation. In other words, if the Ohio General Assembly passed a law, it would be struck down as unconstitutional because the defendant has constitutional rights which supersede any legislative rights that the victims get. So the only option you have is this, is to put them on equal footing with constitutional rights, constitutional amendments, basic constitutional law. And as far as something that Mr. Oglesby said before, the reason why police officers are at the table is because they represent the state of Ohio. The prosecuting attorney does not represent victims. The prosecutor represents the state of Ohio. The victims don't have a right to sit at the table. That's not the case. That's why law enforcement is sitting at the table. And the victim is usually a witness. And I've never seen a case where a defense attorney has said, motion to separate witnesses.
Okay. Next question. Can victims deny the accused access to any documentation that is requested by the defense under this proposal?
Can you repeat that?
Okay. Can victims deny the accused access to any documentation that is requested by the defense?
Generally not. There is some HIPAA, or there is sometimes when you have child abuse cases where you have child rape or sexual assault case where the medical records are not allowed to be circulated to the defendant. In other words, they can review them, but it's what they call counsel only. And you put a stamp on that saying it's counsel only, so Mr. Oglesby would get it, but he has an obligation not to share that specific document with his client, and that's under the criminal rules.
Under the new law, it basically says that it's section 10A(6), except as authorized by section 10 of Article 1 of this Constitution, the victim can refuse an interview, deposition, or other discovery requests made by the accused or any person acting on behalf of the accused. The deposition aspect of it is the only one that really troubles me because generally any witness can refuse to talk to the defense attorney. But a deposition is usually used when we feel that the person we want to depose will not be available. And that's why we have a deposition. Now, generally speaking, if a victim is not available, that certainly helps us. So if the state wants to have a deposition, I think that would cause the state more trouble than it would cause the defense, because we're talking about the victim. My time is up.
Okay. Maybe this will be covered in some of the other questions. Does this bill affect separation of witnesses during a trial?
Yes, I think it does. In fact, I know it does. That's one of the primary reasons why this bill was submitted by the victim advocates groups out of Columbus. I talked with Franklin County Prosecutor Ron O'Brien, who's close to the ground there, and just today, and he told me this was one of the main purposes of the bill, was that crime victims, people whose kids were murdered, or whose spouse was murdered, or home was broken into, or a victim who was sexually assaulted, had to leave the courtroom during the trial. And they felt that it should be a right of theirs to sit through that trial. just like the criminal defendant does. Can you imagine such a criminal defendant, you have to leave while we try your case? I don't think anybody think that'd be fair.
Well, and quite frankly, it's done. I mean, you may have situations where an accuser is a child and the defendant is put out of the courtroom. But generally speaking, ladies and gentlemen, to not have a victim in or a victim in, it really doesn't change too much of the dynamics. The only problem is if that person hears some testimony in the trial and then they tailor their testimony toward that. There's a reason for why we have the separation of witnesses. And we don't want to trample on the Constitution so that a victim can be in the courtroom. Now, if a victim wants to watch the trial, then the state and the court can set up a camera where they can actually watch the actual trial. But there's no real need for them to be in there. If they want to be in there, that's generally not too much of a problem unless they violate some rule where they have advance notice of what a person's going to say and things of that nature. So that's not that much of a problem.
Okay. Who would take the appeal of the victim if the prosecutor does not want to go forward because he or she doesn't think it's worthwhile?
It's a good question. They'd have to get
Me.
private counsel?
Me.
Jeff?
Okay.
There's your answer.
You know, and not to cut Kevin off, but that's the thing. And see, when I spoke earlier about mischief being created, if the victim doesn't get something they want, that's usually from the prosecutor, because we usually don't have that much conversation, the victim and I, unless, you know, I'm consoling the person, and which I do, because I'm from a small town and I usually know quite a few people and their cats and dogs. So you have a situation where if the victim is upset with the judge or the prosecutor, then they can petition the Court of Appeals.
They used to go to the register though.
Yeah. And these things are not addressed. These things are not addressed to the defense. They're addressed to the prosecution. So when you're talking about the rights, but there's no teeth in it. It says this section does not create any cause of action for damages or compensation against the state, any political subdivision of the state, any officer, employee, or agent of the state, or any political subdivision or any officer of the court. So you have this law, and if you don't get what you want as a victim, oh well. So there should have been something put in there that it does create a cause of action. I can read, I'm going to yield to myself. Okay, on the next question.
There's a follow-up question that actually may cover some of this. Thank you. What judicial outcome can victims expect upon an appeal?
Well, with this Court of Appeals, right? Yeah, that's, again, the law is so undefining at times, you just don't know what's, I mean, like I say, not in these specific words, but I tell you sometimes, hey, stuff happens, you know, and you just don't know. But by and large, just because you may not like the remedy doesn't mean you shouldn't have the right. I mean, that's the key thing to understand. You don't get away with the right because you don't maybe are confident of the remedy. And believe you me, prosecutors and judges are very, very cognizant of victims' rights because they know the tragedy they suffered, and we deal with this every day. And they also know that there can be some public outrage if you, once again, re-victimize a victim through the criminal justice system as opposed to safeguarding the rights that are accorded today and hopefully tomorrow after Marcy's law passes.
You know, as a defense attorney and as an attorney, I deal in the alternative. And when I look at a law such as this, I can see all types of things that really could be advantageous. You know, we've had, or at least in the black community, we've had quite a few tragedies wherein prosecutors won't prosecute. Or that's how we feel. Well, based on this law, if I'm aggrieved, then I think I can take my case to the Court of Appeals, which really isn't a bad thing. You know, because a victim is a victim, and it defines what a victim is. And to secure victims' justice and due process throughout the criminal procedure. So I think that if the state doesn't pursue a criminal charge, then maybe I just run up to the Court of Appeals and ask them. You know, so it really may not be altogether that bad when you look at it. And I think it really creates more headaches for the court system and the prosecution. Remember what I said, when mischief is created, that's why you have laws, and I think you have these laws because the victims didn't get what they want, but I think the victims should get more. So.
Okay, this is in editing of this question. Suppose that the accused is innocent of the crime and the victim wants to continue prosecution of that crime with that same perpetrator.
All my clients are
Accused.
innocent. Go ahead, Kevin.
Well, we have those situations, you know, at times, and I often say this, as a prosecuting attorney, I find more people not guilty in probably a week than a lot of defense attorneys do in a year or lifetime, because we make those assessments. My job is not only to vigorously prosecute those who have committed crimes, but my job also is to vigorously protect people from being falsely accused, and we do that each and every day. So we do have those situations that arise where an accused wants someone to be charged, and you may not hear about it, you may not read about it, but I'm telling you, it happens every day, and we make those charging decisions, and where they're really tough decisions on defense, we present it to what's called a grand jury, and the grand jury then makes that decision. Now, let me just tell you, grand juries are like you folks. They're like people who sit on juries. I know they've been demonized over the last year or two. They're stupid. They don't know what they're doing. They're led by the prosecutor. They're intelligent, bright people who are the conscience of the community that sit there and make very hard decisions, charging decisions.
You know, that brings up, you know, a concept that can also create problems. Earlier in my career, there was a prosecutor in Lorain County, Greg White, and Greg White and his people would charge a person with basically one crime, and they wouldn't deviate. They would rarely reduce the charge. Either you go to trial, they dismiss it, that was it. In other counties, prosecutors will, I don't want to say overcharge, but they will make sure they get everything in there. And what can theoretically happen when a prosecutor, and I don't mean to be dismissive or derogatory about overcharging, but charging things to make sure the prosecution gets everything in. Well, a lot of times that's done so that the prosecutor can have a little give and take. And under this particular law, the victim could probably say, look, I don't want those charges dismissed, I don't want a plea bargain, and then run it up to the court. And that's gonna handcuff the heck out of our prosecutor here and in other counties where they want to have a little give and take. Or if I present to the prosecutor, hey, look, this guy didn't do this, we need the permission of the victim for Kevin to reduce the charge. So it's really, really problematic.
Okay, thank you. I think we'll make this about the last question here. Having a little trouble reading some of these. Does the federal law supersede Ohio law in regard to this subject? And why have an Ohio law if there's already a federal law on the books?
There is a federal law, and I had it somewhere in here in my due diligence. It's 18 United States Code, section 3771, and it has crime victims' rights. And one of the things, it's similar, and Marcy's laws are going all around the United States. And what really kind of concerns me is why they don't put more teeth in it. And in the federal one, it has to do with federal crimes and federal rights. So you try not to get those two mixed up. But then again, if somebody said, hey, look, what they committed was a federal crime, then I would suspect under Marcy's law, federal, they could go to a federal judge and file an appeal. And in the federal law, the court has 3 days to rule on it. It's rather quick, and they cannot delay the trial more than 5 days. So, all these rights and things like that are included. There's scant law on a lot of these cases. The only real issue was restitution, whether or not a crime victim should get restitution before the state would get court costs and things like that. And I think the courts in California ruled that you get the restitution first.
With regard to that, I think the federal, I haven't done a comparative analysis, but I think it applies to cases involved in federal court. We're involved in state court, in the state courts of Ohio, and that's why it's applicable. Something that Jeff said earlier, I understand where he's coming from, and that's sometimes a concern, but again, I said before that the prosecutor represents the state of Ohio, does not represent the victim, although we do everything we can. About 99% of the time, when we reach a negotiated plea agreement, the victims are on board because we go through, explain everything to them, knows about this. But I explain that to them too. That I do not represent you. I represent the state of Ohio, do justice, and there are times when I go into court, have the victim sit back there and tell the judge, here's our plea, and it's rare, but at times I say, the victims are here, they don't agree with it, but here is the plea, it's based upon the evidence and what I think is the appropriate ends of justice here, and that does happen. So they don't have any veto power when it comes to that. And 99% of the time, we're holding hands walking down and then they go in disposition of the case, so.
Okay, thank you. I did have a few more questions, but I think they begin to repeat one another. I would encourage everyone who still has continuing questions after our program this evening to go to our speakers and ask them so you can explain a little more specifically what all you wanted to inquire about. And I would like to have everyone please thank our speakers. I think they did a great job this evening. We'll give everybody a chance.